So welcome everyone to our weekly Greenleaf Connect event. Today we welcome back Attorney Sharline Green, who runs her own law practice here in Georgia with a focus on elder law, trusts, and estates. She'll be speaking with us today about estate planning and that process and give us more details of how that works. To start us off, here at Greenleaf Connect, we hold a weekly forum for us to get together and talk about all things Greenleaf. It creates a space for us to be direct, informative, and build transparency for our audiences on specific and important topics like estate planning. As always, we like to review our rules of engagement for our time together. First, you can change your presentation view by moving the slider between the presentation and the speakers to make them bigger or smaller. We do ask that you mute yourself during the presentation portion of our meeting to avoid any feedback as we present. And we will hold a live Q&A session at the end of the presentation, so don't be shy. And a friendly reminder, this session is being recorded and will be made available on the Greenleaf Connect Workplace page for future reference. Attorney Green will review her presentation agenda with us here just in a moment. And after she presents, we'll close out with a Q&A session and our upcoming dates. So please join me in welcoming back Attorney Sharline Green. Welcome, Sharline.
Thank you. Thank you so much. All right, it's such a pleasure to be back with you guys on this St. Patty's Day. I was just talking with Natalie and saying this is the adult holiday. You know, this is the one we get to get excited about. So responsibly, but this is our holiday. So it kind of went over my head and didn't realize it was, but normally I sure do get excited about it. And this is another topic I get excited about talking about, and that is estate planning. I love to talk about this particular topic here. And so this is our points of discussion for today. We're going to talk about what is an estate, because to begin talking about estate planning, we need to have a firm grasp of what an estate is. Then we'll talk about what a probatable versus a taxable estate is. Then we'll define estate planning. We'll talk about when to review your plan and will or trust. So let's get right into it here. What is an estate? Everything that is a part of everything that you own when you pass away, regardless of the amount or the size. It includes things like, of course, your big items like your house, your car, your bank accounts, things that you would, you think about, your checking, your savings account, your CDs, and these things are a part of your estate. I've had, folks come in with a spouse passing away in a checking account in the other spouse's name, and they don't have access to it. And, that because that account is a part of the deceased spouse's estate. And so they have to go through probate in order to get access to it. Investment accounts, depending on the amount of money that's in the account. Investment accounts, of course, like stocks and bonds and cryptocurrencies, of course, those are part of your estate. But other things like your life insurance policies, those are part of your estate as well. Retirement accounts, IRAs, 401ks. And things like your furniture, your electronics, your jewelry, artwork, coin collection, stamp collection, and a client with a very interesting extensive stamp collection and a comic book collection. I mean, that was very impressive and worthwhile and what's the word I'm looking for? It was worth something. The word eludes me, but it was valuable. That's it. It was valuable. And although he wasn't, trying to let go of it, and it wasn't holding on to it for that purpose. But even though I advised him that even though it may not have been valuable to his immediate family member, that there were other folks that it would have been valuable to. And so to make sure that in his planning, he targeted it towards individuals that would find those things, his life work that he'd been collecting, valuable. So, and all of the personal properties and items. So basically, your estate is everything you own when you pass away. So this is important. It's an important part to start off because I often have clients who come to me and say, "Oh, I don't need to do estate planning because I don't have anything. I don't own anything, or I just own, it's just very, very small. I just have a very, very small estate. I don't really have anything. It's very small and minimized." So estate plan is not really about the amount or the size, it's that you have, and we all have something. And so that's, if you have anything that falls into any of these categories, then you have an estate. Anything you own, if you own something, then you have an estate. And the question is just, what do you want to do about it? So I like to start and just take a minute to talk about here the importance of financial organization when it comes to your estate. And this is where I start off with my clients when clients come to me. So understanding things like your net worth and being financially organized. So all that is just being able to quantify what the value of everything that you own versus everything that you owe, and doing things like doing asset classification. So there in the beginning of my presentation, we kind of classified various types of assets. So like you had your real property, like your houses, and then you had your vehicles, you had your financial assets, then you had like your retirement accounts and things of those. So assets, classing assets in grouping assets together in terms of their likeness. So because different class of assets have different rules that are followed for their transfer to the next generation. So real property have different rules from financial assets. So understanding what those rules are is very important for their transfer. Also, make sure you understand how they're valued, especially when we're talking about hard to value assets like artwork or artifacts or family heirlooms or stamp collection, art collection, or comic book collection, things like that, collections. So if you have hard to value assets, doing the legwork to go ahead and value them while you're alive and keeping the paperwork attached or with somewhere where your representative can find it, personal representative can find it after you pass away, will go a long way to ensuring that those assets are treated properly. And also notating where your assets are, especially hard to locate assets like land. If you have land in another state, or you want to make sure that you have the deed to those assets, to the land, in a safe deposit box with your other estate planning documents, things of that nature. So I often get clients who says, "Oh, grandmother or whatever, she's kind of secretive and didn't really tell anyone what they owned, and was kind of like just kept to herself, and now we just we're at a loss because we don't know." And yeah, that's may not be, you don't have to like tell everyone, but certainly, even if you don't want to disclose that, you do want to have somewhere where you keep a good record of everything that you have. And they're organized and they're updated in terms of value and location. And then you allow the individual that's going to be your agent, your trustee, your executor, your financial agent, at least let them know where the records are, so that they can access it in your incapacity or in your death. So that's really important. So maintaining good financial records is essential for, like I mentioned, incapacity and death. And then the last thing in this area of financial organization is being sure to periodically check on beneficiary designation. So that's super, super important. I've had on several occasions seen this go, both ways. I always say every couple of years, 2 to 3 years, do pull those beneficiary designations out. I think every good agents will send out a form for you to double check your beneficiary designations on things like your life insurance policies, but other things like retirement accounts sometimes go overlooked for some time, and certainly things like your pension accounts. But where this can cause some issues is if there's a death. So, for example, I had I was doing some estate planning for a husband, a widow, whose wife had passed away. And he had a pension. He told me that he had a pension, and he had his wife, of course, listed no, sorry, in this case, he had failed to list his wife as um no, his wife had failed to list him on her pension. When she passed away, he was unable to collect. That's how the story went with that one. And that was about 40 or $50,000 that he was just unable to collect, because the policy there was, although he was a spouse and could prove that he was a spouse, um, she had to listed him as a beneficiary. So, and she just didn't do it. She just, I guess, assumed that it would have been automatic that he received the funds. And then I've had other situations where spouses had listed a spouse but failed to update it because they had, gotten divorced, and that caused all kinds of issues. I had one ex-spouse that was just super happy because um, a deceased ex-spouse did not, fail to remove her, and to the new spouse's discontent. So those things happen. So you definitely want to make sure that you update. And in the situation of the widow, that was just so unfortunate, because he definitely could have used, I think it was 40 something thousand dollars. He definitely could have used those funds had his wife listed, followed through and updated and listed him. So be sure that you check those beneficiary designations, make those designations if you have it, not think that you have and didn't, or, check at least, once a year. I get someone, when I tell them to do this, they come up and say, oh, on this one little small account I had, that I opened way back, this little amount, I had this beneficiary and I never got that I had put this person on, and so glad you told me, because I was able to take them off, something like that. So definitely check those beneficiary designations. And so wanted to touch a little bit on your probatable estate. So basically, your probatable estates will apply if you die with a will, that's testate, or if you die without a will, that's dying intestate. And so basically, dying with assets titled in your name that do not automatically pass to a beneficiary or by operation of law will cause your estate to go through probate, so that those assets can be freed up so that they can pass on to your beneficiaries under your will, or to your heirs of your estate. So the purpose of probate is to free, one of the purposes of probate is to free up assets so that they can pass on, because if you are an owner of an asset, for example, real property, no one can take your name off that asset. I started my career in real estate and was a real estate attorney for 10 years, and the first 10 years of my career. And I would always get so tickled when individuals will call me and say, oh, I want to take someone, I did a quick claim deed, I added, someone to title, and I want to take them off. I want to take them off title. I want to take this expert person off title. So you can't do that. You gifted them your interest in the property. It's now theirs. They have to take themselves off. You cannot take someone off title. And thankfully you can't. Can you imagine if people could just take whomever they wanted off title? It would be a nightmare. So that's the case. If you pass away with assets titled in your name, those assets can't be removed unless you go through your name can't be removed from those assets unless you go through the probate process. If you have a will, the probate court will review the will and rule on the validity of the will, and so that the assets can be distributed pursuant to the instructions of the will. If you did not have a will, then the probate process is to appoint an administrator that will distribute the estate pursuant to the laws of intestacy. So the other purpose of probate is to pay the legal debts of the estate. So typically it is the heirs of the estate, or the administrator, or the executor, or personal representative of the estate that initiates a probate process, but a creditor of the estate can also initiate a probate process, because during the process, creditors are notified so that they can get paid from the estate. So those are the purposes of the probate process. And your probatable estate are all the assets that are titled in your name that need to be released so that they can pass on. So the gross value of all the assets titled in your name at the time of your death make up but the gross value of all the assets titled in your name at the time of your death make up your taxable estate. So you can have assets like your life estate, your life insurance policy, your retirement policy, your bank accounts that are jointly held, other assets that were by operation of law pass by beneficiary designation to be either like in a jointly held situation to the joint account holders. For example, if you have bank accounts that are jointly held, owned and you pass away in the state of Georgia, they will pass to the joint account holder. You have a life insurance retirement account, those accounts will pass to the beneficiary. So they don't go through your estate. They're not a part of your probatable estate, but they are a part of your taxable estate. So all assets that are titled in your name, period, that any assets associated with your name at the time of your death make up your taxable estate. The assets that don't pass by operation of law or by beneficiary designation are part of your probatable estate. So there are ways to get all of your assets to pass by operation of law, beneficiary designation, and there's ways to not have a probatable estate, even though you'll always have, most people will have some form of taxable estate because you will have an estate. Most adults will. So what is estate planning and what's its purpose? So it's, of course, as it says in its name, and surrounded or enshrouded in planning and preparing. So it's planning and preparing for what happens to you and your estate when you die. It's the basic premise there, but not just death. So a lot of folks, of course, when you think estate planning, you think will, they think dying, what happens to my stuff, but it also encompasses mental incapacity too. So it includes not just what happens to my estate when you die, but also when you become mentally incapacitated, incompetent, disabled, or any other condition that renders you incapable of managing your own affairs. So anytime, of course, death does, but any point in time that you're not able to manage your own financial affairs or your own affairs for whatever reason, you want to put a plan in place and designate individuals that can do that for you. That is the purpose of planning and preparing. That's the purpose of estate planning. It involves designating individuals to manage your financial affairs. It involves communicating your healthcare wishes. And it, of course, involves designating individuals or groups that are going to get your assets. So this is basic. Basic estate planning is going to cover these areas. If you haven't covered all of these areas, if you only addressed what happens to my assets when I pass away, then you really haven't done estate planning. You just addressed what happens to my assets when I pass away, but you've left some holes, like we like to say, you left some holes in your planning. So basic estate planning encompasses these areas here: death planning as well as incapacity planning. And then we have what we like to say enhanced estate planning, or just having a good estate plan. And that would include things like if you have minor children, which is something that my office focuses on, planning for parents with minor children under the age of 18, correctly naming guardians. So that will involve more than just jotting down names of individuals in a will or in a will. It involves thinking through the best individuals that are best suited to bring your children to maturity. That involves their characteristics and traits that you have, that you want that you want your children to be around, to be influenced by. And it also involves having, thinking about short-term guardians, not just long-term guardians. Those are long-term guardians, permanent guardians, but also in an emergency situation, having folks that your children can call on, especially if they're very, very young, create a list of individuals that can be go-to individuals that can step in, especially if your long-term guardians are out of the state. So really having a plan and thinking through, within the first 24, 48 hours, what happens to my children if something happens to me? Where do they go? Who do they stay with? Where are they staying? Because if these questions aren't answered, the state's going to step in, the states are going to take control of your children. And at a time, the worst possible time in a child's life, and they have lost one or both of their parents, the last thing that they need is to have a system being in a system. So every parent, wants the best for their children. And so thinking through this process of what happens to my children if something happens to both of us. If one parent is, alive and available, of course, the other parent can step in. But also, even if both parents are there, but one is unavailable, out of the state, out of the country, or just far away, I always say we want to have at least 3 individuals that children can count on within an hour that can get to them if there's an emergency, and that can be with the children. And then, of course, thinking through your long-term guardians, and then not just putting folks on a list. If they're a couple, thinking about, if the couple breaks up, if you're going to designate a couple, well, who do the children go through? So all the areas where a judge will step in and substitute their decision for yours, going ahead and making that decision. If there are individuals that you would not like to be named or considered under any circumstance, because there are cases where the individuals that you've chosen, your top 3 or however many you choose, for whatever reason, by the time if something happens, they may not be able to shoulder the responsibility, so a court is stepping in anyway. Well, if there are individuals that you do not want the court considering, you may want to jot those down too. So there's a lot that we can talk about when we're considering when minor children are part of the equation, and your estate will fall into the laps of minor children. And the other thing, of course, is providing for them. So, of course, children cannot manage their financial affairs. And so, as a parent, I'm of mind, it is my personal opinion, that the financial burden of bringing a child or your child to majority is your responsibility, whether you're here or not. And for a couple of dollars a day life insurance, you can create a plan that involves some mixture of liquid assets, even if you have to supplement it, like I said, with life insurance, and have funds that could take care of that, even if it's just providing for their basic necessities. Because again, if you don't, this is an area where the state will step in. And I'm always of a mind that parents are much better suited to do this. This is a parent's job, and we as parents, of course, all parents, if this was on the forefront of our minds, it's just an area that we don't think about as often. Would of course say, yes, this is something we want to do. We want to make sure that we are protecting our children so that the states do not have to do this. And I don't believe this is the first job of theirs. This is the last resort. This is the last thing they want to be doing, but they do it if it's not done. So providing financially for your children to the age of majority and beyond. Then, of course, in place, setting up individuals as guardians. The guardians, of course, will take care of the children, but you can also set in place financial managers called trustees or conservators. And they don't have to be the guardian. Of course, it can be the same individuals, but I like to separate guardians from the trustees. So the guardians are the ones who have the care and the nurture of the children to raise them up. The financial managers or trustees are just managing the assets that are left behind for the children. Now, they require 2 different skill sets. Depending on what your goals and objectives are, and those are the kind of things you want to sit down and make sure is in your plan when you're talking about a child. If your goal and objective is longevity, making sure that whatever's left is managed well, so that it can be there for the child again, beyond 18, give them a good start in life, possibly be there throughout their life, and maybe for the next generation. Then it's going to be really important that the person you select to manage your children's inheritance has a solid financial background, or will surround himself with a financial team that will invest wisely and manage wisely. And so, don't be afraid if you are in this position to put in together a plan for your children. If you have to pick different individuals for the guardianship team versus the financial management team, they require different skill sets. If you're lucky enough to have people, the same individual with those skill sets, then that's fine. But it certainly can be different individuals. And I like it to be different individuals too, because when you're the one raising the children, you kind of know their needs. You sometimes blur the lines between um, what's a need versus a want. And so when you just have someone that's focusing on managing the funds, it leads to more. If your goal is if your instructions were or objectives are to be as financially conservative as possible, because you want to provide for beyond majority and such. But it could be your objective is just to provide a very comfortable life for your children. So if those are your objectives, then this wouldn't you know it wouldn't matter as much if the trustee is as conservative in their distribution. So it does matter what your objectives are. But the point is, you need guardians and you need financial managers when we're talking about young children. And also minor children. So the younger, of course, you need them, but if they're under 18, they'll need them as well. Also making provisions for beneficiaries with special needs and financially irresponsible beneficiaries. So even outside of minor children, there are other classes of beneficiaries that would need special attention. For example, if you have, like I mentioned here, beneficiaries with disabilities that may be receiving government assistance, or you just want to ensure that you have set up a trust or something similar in place like you have for your minor children, someone that will be there for the lifetime of the disabled beneficiary, that will manage their financial affairs, maybe because the beneficiary will not be able to do so, that will take care of their needs, their financial needs. It's important to create a plan that will do that. And or if the beneficiary is receiving government assistance, it's essential that special care is taken when leaving an inheritance to someone who's receiving government assistance, because that could certainly disqualify them from receiving their need-based government assistance. So you'd want to do something, like create a special needs trust, so that the beneficiary can continue to receive their need-based government assistance and have the benefit of the inheritance as well. So there's a way for them to continue to do both. Also, if you have adult children or other beneficiaries that are adult, if they're not your children, and you want to, leave them, benefit them with a portion of your estate, but you are concerned about how responsible they'll be, you can still, leave them some portion of your estate, distribute portion. Just make sure that's a part of the plan. Make sure that's a part of the discussion. There's a way to do that, and so that they can receive the benefit, but you can also accomplish your goal, if there's a goal for them, creating a trust. So there's just a way to take that into consideration in doing your plan. And a good estate plan takes into account who the beneficiary is. We talked about that last week, that estate plan is on 3 legs: what your goals are, who you're planning for, and what you have. So this is focusing, these first 3 points is focusing on your beneficiaries. So if you have minor beneficiaries with special needs or disabilities, and beneficiaries that are fiscally responsible, we want to certainly incorporate that into the plan. That's a part of the discussion, so that we know how we're going to plan going forward. Also, a good estate plan will not just have your basic documents, but it will go a step further and leave instructions for your care and for your children's care. So you can leave behind, if there's, I met, for example, I met a um, client who had a son with special needs, and she had created this booklet, and it was very touching, with just a list of all of the things that he liked. He did not communicate very well, and she just wanted to make sure that if she was not around, that this would just be something easy, that the caretaker could go to and know um, some of the things that was necessary for his care, and just some of the things that would just make his life easier, some things he liked. But outside of even an extreme case like that, I encourage my parents to leave behind instructions, or not just even instructions for their care, but notes, well wishes, especially if your children are very, very young, things that you would like to say to them when they receive, at different ages, 18, 21, on their, when they get married, or graduation or something, if you weren't here, or just, tell them how you feel and get that down. Something that they could listen to. I had a mentor who told me a story when she was when I was setting up my practice, and it was her dad had called her on the day that he passed away, and left her a message early in the morning, just saying, hey, and she didn't answer, so he left a voice message just saying, hey, just calling, checking in, seeing how you're doing. Sorry I missed you. I love you. Basic message there, and hung up. Later on, he got into a terrible accident and didn't make it home. And she just kept that message, kept saving it, trying to hold on to it for, years, as long as she can, just because it was something. It was his voice. There's something about that. So anything you can leave behind, even if it's just a little recording, or a written, a letter, or something as detailed as instructions, if you want to do that, if your children are very young. Some parents will leave things like doctors, primary care, dentists, if they have allergies, things of that nature. And then also for your care. So if there are things that you want to have happen, places you want to stay, if you were ever incapacitated and not able to communicate. I had a colleague who had a client and told me his story of a client who had a list of people she did not want to visit her if she was in a home and could not communicate. So she just wanted to make sure she went ahead and had her list of folks that she didn't want visited. So you can do that if that is something that is important to you. A good plan is also for those business owners or individuals who have small businesses or have a business on the side. Will plan, incorporate your business. That's really important. A business is an asset. And so it will incorporate, in the plan for your business in the event of retirement, disability, or death. And one of the ways to do that is with insurance. So with a good estate plan is not just about, documents, not so document driven, but it's about the process and making sure there's a whole plan. And so life insurance, I found myself talking about not just life insurance, but insurance quite a bit in our planning process, because it's a great way to plug the holes. So, if for example, during your time when you're young and you're working in your income driven years, if your family were to relies on your income, and God forbid something were to happen to you, you can replace your income with life insurance, or if with disability insurance, if you would become disabled. And certainly same thing with your business. You want to make sure that you have these things in place. Long-term care insurance, or long-term care planning as well, which falls under the elder law wing of the estate planning, is really important as well. And the earlier you start looking at that, the better as well, because long-term care insurance is rare and hard to come by, especially the older you get. But procuring this insurance in your younger years will help. The estimates that 1 in 2 Americans will need some sort of assisted living in their latter years, and that number is going up. We're living longer, And so more Americans are needing help in their latter years, and so that care is relatively expensive, $6,000 to $7,000 monthly. So thinking about having insurance that could pay for that care, if you have to move into a facility or have someone come in to help you because you aren't able to stay by yourself, either to um, mental deficiency issue, that's on the rise, Alzheimer's, dementia, so you're not able to stay at home, or it's a debilitating illness that you're not able to take care of yourself, and so you have to move into a facility. That care can be very, very expensive. So thinking about supplementing that with insurance that as early as possible is really important for a lot of families, and having that discussion, making that a part of your plan so that you can preserve. All this is so that you can preserve your estates. The more you have, you cover with insurance, the more you're able to preserve your estate later on, so it can be transferred to your heirs. So that is always a part of the discussion. And then, of course, thinking about estate planning as a total wealth transfer. So that's one of the things my mentor and I, we talked about when I thought about transitioning into this practice area. So not just transferring your dollars and your cents and your houses and your cars. Of course, that's important. But like I mentioned with my mentor's dad, when he passed away, and she held on to that voicemail of his voice saying, "I love you." That was invaluable. It's like the MasterCard commercial. It was priceless. That, and thinking of estate planning in those terms. So like I mentioned with the instructions, so not neglecting that part, writing down your thoughts for your family, your wishes for them, transferring what I call your intangibles, your knowledge, your experience, your family traditions, or just start jotting down those thoughts and making that a part of the process. So I encourage my clients to do that. And in saying this, I've kind of the last, I guess, 6 months, have kind of strayed away from doing that. And this presentation has reminded me that I need to get back to my roots and basics, because this is really, really important to me. And it's a really important part of a good plan. Thinking of estate planning as you're more than just what you have, but also who you are. So keeping that in mind. So how do we start with planning? Well, every plan starts here. So we started off by talking about getting financially organized. So you want to make sure that you keep good financial records. So asset classification, valuation, location of where your assets are. What this will do is make sure that whatever you have will be easy to locate if something were to happen to you. Because if your family can't locate what you have, they may end up in the Georgia Unclaimed Property Department and become the property of the state of Georgia. So you want to make sure that you keep good records. And then, of course, there's a difference between a basic plan and a good plan. Of course, you want to always have your bases covered, but like we mentioned, there's a lot of things that, and this is just a 30-minute or whatever presentation. There's so much more that we could go into. So you want to choose a practitioner that will educate and guide you and support you to making the best decisions that are going to be good for you and good for your family, and that are going to protect and provide for your family and preserve your legacy. And then do not forget to review your plan. So estate planning is a dynamic process. So as your life changes, as the laws change, you do want to make sure that you update your plan. So at least every 3 years, look at it, take it out, dust it off, flip through it, and just make sure that it still meets your needs. It still addresses the things that it was designed to address to begin with. So if you have any questions, feel free to, ask them at this time.
Awesome. Well, thank you so much, Attorney Green. We do have some thoughtful pre-submitted questions for you, so we'll go ahead and get started with those. So first, for clarification, an estate plan is not a document itself, right? It's more of a review of our estate and putting together the necessary documents to execute the plan, like a will or trust, correct?
Right. So I think that's a better classification for it. So estate plan is just that it's a plan. So it's a plan that incorporates documents. So documents are part of the plan, but you also want to have individuals that will execute the plan as it goes along, and it incorporates what you have, what your objectives are, who you're planning for. Those are all a part of the plan.
Okay. Now, what if I co-own an asset? How does that work when I or the other person passes? What decides what happens?
So that's a great question. So that goes back to, being organized and what class of asset it is, what type of asset, how is it classified and where it falls under. So it depends on the asset. If it's real property and it's co-owned, it depends on if it's co-owned with the survivorship aspect, or if you're just co-own it, with no survivorship. So if it's co-owner survivorship, it'll pass by operation of law to the other co-owner. Without it, it will go through your estate. So it depends. Bank accounts that are co-owned will pass to the other joint account holder. So, and brokerage accounts will typically do that as well. So there's really no blanket rules. Most of the times, co-owned assets will it depends on the asset. Let's say that. So you do want to classify your assets, know what you have, and it depends on the asset whether or not it will transfer to you. And you do not want to assume that just because it's your spouse or just because you own it that it will transfer. You do want to make sure that you're properly educated on how that particular asset transfers upon death.
Makes sense. Now, here's an interesting question. What can I do, if anything, if I don't agree with how someone is managing an estate of someone who I know who passes? For instance, if I feel like the deceased had intentions that the executor is not following, or we believe we have a stake in something and we're not getting it.
Mhm. So it depends on if you're an heir of the estate and or beneficiary. So if there is a will that names you as a recipient of getting some asset or some benefit under the will, and the executor, the personal representative of the will, isn't doing their job, there's always a fiduciary duty, or even if there isn't a will and you're an heir and you feel the administrator that was appointed by the court um, isn't doing what they need to do, there's always that fiduciary duty, that duty of care, that duty to be sure that you're carrying out and acting in the best interests of the estate and the beneficiaries of the estate, or the heirs of the estate. And so you can always bring an action that says, hey, court, this person's not doing their job. And so that's always a right that you have, but we just want to make sure that you can prove that. So make sure you've got a good reason. Always try to resolve it first before getting the court involved. But sometimes that happens, and understand that it is a difficult task to wrap up an estate. So being an executor or an administrator is a tall order. So do try to work it out first. Ask questions. I would say, give 30 days, say, hey, what's going on here? I haven't heard from you. Can you please respond? If you haven't heard in 30 days, say, if I don't hear from you 30 days, I'm going to take action. But if you haven't heard in 30 days, then proceed to take action.
Okay. And our last pre-submitted question, how can I make sure a beneficiary follows my wishes in regards to things I leave them? For instance, how to use life insurance funds that I wanted them to have to use for specific purposes. Does my will do that?
So, okay, so that's a couple of things you've brought in there. One, with life insurance and beneficiaries. If you've left your life insurance proceeds to a named beneficiary, that beneficiary gets that check. They can do whatever they want with it. So if you and then if you've left it in your will, let's say you made the beneficiary of your life insurance your will, And it just says to go to different individuals or to a charity or whatever it is. It more than likely is going to be distributed how it is in your will. The only way that, or if you're wanting to be very specific about distribution, during either accomplish a particular task or over a period of time, you want to create a trust. That's what a trust is designed to do. You appoint a trustee who's there to carry out that wish over a period of time. And so you create a trust. You would like those instructions in the trust. You'd make the trust the beneficiary of the life insurance policy, and then in the trust agreement, you would flesh out those instructions and go from there.
Great information. This does conclude the main portion of our presentation, and we do want to thank Attorney Green for speaking with us again today. And of course, we want to thank all of you for joining us as well. We will now close out with some very important upcoming dates that we have here on the screen for you. So first, don't forget today we have our first annual Green Fest here at the office at 3 p.m. So we hope to see some of you there. And then as always, tomorrow our recording for this presentation will be made available on Workplace. Then next Wednesday, we have our Tiny Pulse question for you. And again, if you have not filled out the Tiny Pulse questions from this week, you still have time to do that as well. Then on Friday, March 25th, we have our Greenleaf Quarterly Volunteer Day at the Unearthing Farm that was moved from last Friday due to the weather. And you will need to RSVP in the calendar invite that was sent out. If you do have any dietary restrictions, please note those as well. You can either do that in the calendar appointment or send those to me because we will be serving lunch. And for our Greenleaf Connect schedule, we will meet with Attorney Green next week for our last session in our legal literacy series, where we will discuss the differences between wills and trusts, which she definitely touched on that a little bit. So tons of interesting information that I'm sure we'll learn about those differences. And then we'll close out the month with our Greenleaf Women's History panel discussion. So I hope you can join us for that. Last but not least, our weekly reminder to log into our professional development platform, Kudo, to start some exciting development programs. If you have any questions about the system, access, or the programs there, just reach out to me and I'll be happy to help. Thank you again for participating in today's session, and we look forward to seeing everyone next week as we close out our legal literacy series with Attorney Green to review wills and trusts. Thanks again and enjoy your day.
Thank you.